Hearing in the appeal, Sagicor Bank Jamaica Ltd against Mr Seaton and others.
Yes, Mr Shorter.
May it please your lordships and the lady, I appear with my learned friend Ms Ivana Daskalova for the remaining appellant, Mr YP Seaton. My learned friends, the Honourable Mr Michael Hilton, one of Her Majesty's Counsel, Mr Kevin Powell and Mr Sundiata Gibbs, all of the Jamaican Bar, appear for the respondents. Now called Sagicor Bank Jamaica Ltd, but they are the successor to the party who was involved at the material time, and I shall simply refer to them, if I may, as the bank.
Yes.
This is Mr Seaton's appeal from the order dated 11th September 2019 of the Court of Appeal of Jamaica, which is at Bundle 1, Tab 10, page 170, which allowed the bank's appeal from the orders made by Mr Justice Sykes at first instance on 17th of March 2014, which is at 116.301. I shan't ask the Judicial Committee to turn them up at the moment. I shall come to them.
No, well, we only have the documents in electronic form, so all we need is the electronic page number.
Lord, I'm very grateful.
Thank you.
I was saying, allowed the bank's appeal from the orders made by Mr Justice Sykes at first instance on the 17th of March 2014, which is at page 301, and on 24th September 2014, which is at page 353, in relation to the relief to which Mr Seaton and the other Seaton parties were entitled as a result of the wrongful freezing and subsequent debiting of their accounts by the bank. The Jamaican Court of Appeal set aside the orders made by Mr Justice Sykes in relation to compound interest on the basis that they felt compelled to do so by the law as they understood it, as laid down in the Sempra Metals case. The relevant passage in their judgment is paragraph 80, which is at page 128. It will be our submission that that decision was made on the basis of a misunderstanding of what Sempra actually decided and a failure to apply the reasoning in that leading case to the more domestic facts of the present one. On that basis, we invite the Judicial Committee to set aside the decision of the Jamaican Court of Appeal, to restore the orders of Mr Justice Sykes, and in doing so, to clarify, for the benefit of other cases, the proper application of the principles laid down in Sempra.
Before we go there, Council can take it that the board have read the written cases and the judgments below. I wonder if it would assist the board if we were to map out with you certain parameters, as it were. This is a claim for breach of contract.
Well, indeed.
Yes. The contract concerns several foreign exchange bank accounts. Those bank accounts provided for contractual interest. Is that right?
Lord, yes.
Yes. And the contractual interest would accrue on a periodic basis and would then be applied to the account, and the sum, the aggregate sum of the capital plus the interest accrued would become the capital, and interest would then be due on that. So there was a contractual compounding process.
Lord, indeed.
Yes.
That's what the evidence showed at trial.
Yes. And there would have been a contractual rate of interest due on that account.
Lord, indeed. Although
Yes.
the evidence before Mr Justice Sykes from the bank was inadequate in that it didn't specify what those rates were, and the bank was at the time unable to tell Mr Justice Sykes what those rates were.
Yes.
It was partly on that basis that Mr Justice Sykes ordered an accounting.
Yes.
For a number of reasons, and if I may, I'll come to those in the course of my submissions, but one of the reasons was that Mr Sykes was entitled to find out with proper disclosure from the bank precisely what had been credited to the accounts and whether that conformed with what he was entitled to, not
Yes.
merely on the accounts which were the subject of the wrongful debits, but on the other foreign currency accounts as well.
Which had been frozen.
Which had been frozen for a period, my lord, from 1992 to about 1996.
Yes. And
Lord, I'm sorry. I should have said 1991 to about 1996. Forgive me.
Yes.
I'll come to the detail of that and give your lordships the references to the relevant documents, if I may, in
Yes.
the course of...
And further clarification would be helpful. The interest rate of 27.3%. How did Mr. Justice Sykes arrive at that rate?
My Lord, Mr. Justice Sykes arrived at that rate. Perhaps I can give the tribunal the reference to it in the judgment of Mr. Justice Sykes, the second judgment. My Lord, it's paragraph 22 of his judgment on page 315 of the electronic bundle.
Paragraph?
Paragraph 22, my Lord.
22.
My Lord, this may be a convenient moment to mention that my learned friend overnight has pointed out that the agreed statement of facts and issues does not entirely reflect that paragraph. And while perhaps it's a little late for my learned friend to ask to correct it, I can't gainsay the fact that the paragraph says what the paragraph says, and we were simply seeking to reflect that in the statement of facts and issues.
Are you able to point to the relevant paragraph in the statement of facts and issues?
Yes, if your lordship...
Is it 22.2?
It's
21.1.
sorry, Michael. Paragraph 21 of the SFI. My lords, I'm grateful to my learned friend.
Say that paragraph number again, 21.2.
0.1 million.
Lord, I'm obliged. I'm grateful to my learned friend. I'm afraid I didn't have the statement of facts and issues here. It was something that was brought up at comparatively short notice last night.
Yes, so 21.1 explains the rather terse statement by Mr. Justice Sykes in paragraph 22. So Mr. Seaton produced evidence of the prevailing interest rate on foreign currency accounts in that period, is that right? And the judge accepted that?
Those are domestic currency accounts.
Well,
the 27.
Well, that's what I would have expected. I mean, it would be an astonishing rate of interest on foreign currency accounts.
Lord, indeed, although, as I shall attempt to explain to the Judicial Committee, these were unusual times in Jamaica. There was a great shortage of foreign currency, as Mr. Justice Sykes said, and therefore large rates of interest are not unusual. But it is, my Lord, I believe, common ground. 27.3 is the rate for borrowing on domestic accounts denominated in Jamaican dollars rather than US dollars.
But the rate of borrowing, but that's totally different from the deposit rate.
My Lord, indeed.
And so what was Mr. Seaton's evidence from the Bank of Jamaica based on borrowing rates?
My Lord, as I apprehend the matter, I can go no further than what is recorded in paragraph 22 here of the submissions. But my understanding was that there are two... I'll come to this if I may in a moment, but
yes.
There are two separate issues here. Mr. Seaton has suffered, as I shall attempt to explain, 4 different kinds of loss. One is the loss of the money which was wrongfully debited, 300-odd thousand United States dollars. The second is the contractual interest that he ought to have received on that money compounded regularly each month.
Yes.
The third is the loss of use of that money from the period it was wrongfully debited in 1992 until it was repaid in Jamaican dollars rather than in foreign currency at a rate which, again, I shall explain in a moment, in about 2019 as a result of the judgment of the Court of Appeal, and it was repaid with simple interest. Well, that's the third head of loss.
Yes.
And the fourth head of loss is the loss of use of the money on the foreign currency accounts generally during the period they were frozen. Now, each of those requires separate compensation in our submission. The first two of those...
So is it now accepted that interest was credited to the frozen foreign currency accounts then?
Lady, yes,
Right.
but not accepted that it was credited at the correct rate because there was no sufficient disclosure from the Bank of Jamaica. And lady, indeed, in relation to one of the accounts, the account from which the 360-odd million, thousand United States dollars was taken, the account was effectively closed because the balance was taken.
Yes.
The first two of those, as I shall seek to explain to the Judicial Committee, are essentially claims for contractual debts. Albeit that one needs an accounting to work out exactly what it is under Head 2 that one is entitled to. Claims under Heads 3 and 4 are claims for damages for breach of contract, and those are the only ones to which the Semper principles are applicable.
Yes.
Regrettably, in the courts of Jamaica, and I attribute no blame to the courts or to anyone in saying this, that analysis was not put forward in that structured way in which I've put it forward to the committee.
Well, I fully understand your analysis, yes.
And the matters were rather rolled up.
Yes, yes.
So, category 1, the loss of money, is that the 9.2 million Jamaican dollars?
Yes, Lord. It's the equivalent of that, but in truth, it shouldn't have been the 9.2 million Jamaican dollars. It should have been the amount which was actually deducted, which was deducted in United States dollars. What happened was that the bank had a claim against it by, and I shall, if your lordship will bear with me, I will come to this in a moment. There was a claim against the bank, which was for a sum in Jamaican dollars. It sought to recoup what it said was its losses in Jamaican dollars by taking...
Well, debiting Mr. Seaton's accounts.
Mr. Seaton's accounts.
Yes.
If it's foreign currency accounts. We say that was wrongful. But the matter was complicated because the bank itself had claimed a declaration that it was entitled to debit a sum in Jamaican dollars, in Jamaican currency, and that was its claim. Your lordships will bear with me. I will go through these and explain it. It would be more logical, I'm afraid, if I could take this in chronological order.
I will certainly let you do that, but I wanted to mark out initially what were the boundaries, because it seems to the board, I think, that there is a straightforward claim for the return of the sum together with the contractual interest, and the sum wrongfully debited. And similarly, there is a claim for the frozen sum plus contractual interest. And I don't know if the bank disputes that matter. We shall hear shortly. But the issue, as far as you're concerned, is claims 3 and 4, where you claim that you have an entitlement based on Semper Metals, or that we should depart from Semper Metals to give you a loss of use award.
My lord, indeed. Departure, I think, exaggerates our position. It's a clarification. It's a recognition of how these things actually operate in practice in the commercial court.
So can I just get your third category clear in my mind? So the dates are, in relation to category 1, we've got the deduction of the money, which I didn't catch the US dollars sum, but I think you said it's 300.
You said about 300,000, I think.
392,000, I think, was it?
I can give your lordship the exact figures. First of all, it was 369,190 United States dollars and 62 cents, which were taken from account number 101900561, which was the entire balance on that account.
Right. And that is the equivalent of the 9.2 Jamaican dollars, is it or not?
Almost, my lord.
Whether or not it is, that figure of 9.2 Jamaican dollars is raised judicata as far as we're concerned, I understand.
My lord, I'm not arguing it in relation to that. I'm simply talking about what happened, as it were,
Yes, okay.
at the moment. My lord, the legal consequences, if I may, I'll come to.
And then
there was also a further $9,173.50 taken from account number 1090024.
Where are you reading from, sorry?
Well, my lords, it's recorded by Mr Justice Sykes in paragraph 245 to 247 of his judgment. It's also, your lordships will find it, the bank statements are at pages 547 and 546. And they were in evidence before the court below.
Fine. So that's the sums that were unlawfully withdrawn.
My lord, yes.
Then your second category is contractual interest on that money compounded over what are the dates of that, if I may?
My lord, it starts on the 16th of October 1992, which is the date the bank helped itself, again proved by the bank statements and indeed averred by the bank. And it finishes on the date in 2019 when a Jamaican currency equivalent was paid plus simple interest at 27.3%, pursuant to the order of the Bank of Jamaica, because for the entirety of that period, Mr Seaton didn't have his money.
And when was that end date?
The precise date, my lady, I'm afraid I do not have. It's not in the bundles before the court, but it is sometime in 2019.
I'm slightly fearful we're taking you out of order because I think you were going to run through each of these categories.
I was going to run through the dates, my lord.
It would be helpful for me if you could give it to us in the order in which you were planning to.
Yes, well, I think we've clarified some of the...
Sorry, I just want to get clear in my mind before we go there, because we were getting an overview, and I apologise if we've taken you out, and no doubt you'll come back to this, but just so I can have the overview. The third claim is then loss of use of that money until repaid in 2019?
No, my lord. The third claim is loss of use. Yes, sorry, my lord. Yes, it's loss of use of that money. Absolutely. I'm sorry, my lord. I wasn't.
So you're claiming compound interest plus loss of use?
My lord, yes. Because there is a significant difference between the value, the amount you would get simply depositing foreign currency in a bank, and the amount that a businessman like Mr Seaton, and the whole background of this case is that Mr Seaton was a businessman in Jamaica, quite prominent, and possessed a foreign currency which he could use to provide those matters. And it's that difference between the amount that you get credited simply depositing.
And what is the amount of money he's claiming under this heading?
Well, my lord, he's seeking an account. That was the order that Mr Justice Sykes made. Mr Justice Sykes effectively rolled up two different sets of claims. One was the claim for the contractual interest, my category 2, if you like, and the other was the compensation for being kept out of the money, which is my category 3, by saying take an account of what was due, but use the borrowing rate. Unfortunately, he used the wrong borrowing rate. I confess he used the Jamaican currency rate rather than the borrowing rate as a proxy, and I'm going to submit to your lordships by reference to cases such as the Equitas case, that that's a proper thing to do, as a proxy for the loss of use to a businessman of not being able to get at his money, and that proxy is represented by the cost of borrowing, not the amount you'd get on a deposit, but the cost of borrowing, which is significantly higher, of an entity or person of their condition. It's a convenient shorthand, just like, and I'll try and show you, lordships, in some of the authorities, just like the way one doesn't look at the specific loss, one looks at market price and contract price as a convenient proxy on a sale of goods case or something like that.
I have to say, at this moment in time, this sounds to me like double recovery.
Lord, it is not, because there are two separate losses.
If you take out money from an account in order to use it, then you wouldn't be getting the compound interest.
Lord, no, but you would be getting, if you used it, for example, let me start again. Take an example. I've got my money in my account. I've got a need to use it. So I have to borrow that sum. I end up paying the much higher sum of money. Now, what the learned judge has done is he's rolled up the payment that you're entitled to contractually, which is the lower rate of interest, into the higher rate of interest that you'd have to pay to borrow, and say, make an accounting of that, because it includes your contractual debt.
You can't both leave money in an account and use it.
You'd have to, all that you'd be entitled to, presumably, if there is a legal claim under heading 3, is the differential between the rate and what he would have got on the interest, because otherwise, as Lord Burrows says, there's double recovery.
Lord Burrows is entirely right, that if you were being given both Category 2 and Category 3 separately, you would be getting double recovery.
Yes.
But actually, if you get Category 3, which is effectively what Mr Justice Sykes has said in the account, it includes Category 2, because he's not saying do the account and credit that, and then on top of that, credit 27.3% on top of that. He said, look at what they've paid, and if it's less than the borrowing rate, use the borrowing rate, because that includes the two.
Yes, so if Mr Seaton has a claim for 3, then his claim for 2 falls away because it's included within. It's included within 3. 3 is the maximum he can get under Mr Justice Sykes' judgment.
Lord, indeed, yes. and Mr Justice Sykes has effectively rolled 2 and 3 up.
One final question before we allow you to develop your submission. Was evidence led that Mr Seaton in fact incurred borrowing costs as a result of the lack of use of the money, or that he would have used the money for a particular profit-making enterprise which would have earned the equivalent of 27.3%? Or are we inferring it from business practice?
There was some evidence, my lord, of a generic nature, and if I may, I'll show the Judicial Committee that when I get to the appropriate.
Well, then we'll let you develop your submissions. Thank you.
My lord, I'm grateful, and I'm very happy to answer your lordship's questions. It won't knock me off my course, so long as I'm allowed time to finish where I'd hope to get to.
Thank you.
Now, with the committee's indulgence, I propose to structure my submissions in 3 parts. The first, I intend to give some brief words of introduction. I've provided some of that already, but I hope if I do it in a chronological order, it will be easier for me to make the points as I go along. And in the course of that, I'm going to show the committee some of the pleadings and some of the evidence, if I may. Secondly, I'm going to make submissions, some of which I've presaged, concerning the issues which arise in relation to the account which Justice Sykes ordered. And finally, I'm going to make a few very brief submissions on the issues which arise in relation to the order for repayment of 9.2 million Jamaican dollars. Lords, my lady, I'll begin with the introduction. It's a sad fact that the events with which this case is concerned took place about 30 years ago, in the early 1990s. Mr Seaton is a Jamaican businessman of some substance. His name and his companies appear in other litigation, which was referred to in the course of these proceedings and elsewhere. He had a number of accounts with the bank's predecessor, Eagle Commercial Bank. Those accounts included, but were not limited to, 5 foreign currency accounts, which are the subject of an order for an account. In about 1990, Mr. Seaton and his companies were involved in arrangements under which the Jamaica Commodity Trading Company, a statutory body charged with importation, bought and imported milk powder from a Belgian supplier, Prolacto SA. As Mr. Justice Sykes held in paragraph 21 of his main judgment at page 210 of the bundle, there was a severe shortage of foreign exchange in Jamaica at the material time. Mr. Seaton and his companies, particularly Earth Crane, facilitated these transactions by the Jamaica Commodity Trading Company by providing them with the necessary foreign exchange. The methods by which it were done were quite complicated and needn't trouble the Judicial Committee because none of those issues arise. The parties fell out. Prolacto, the Jamaican Commodity Trading Company. There were disputes. The Jamaican Commodity Trading Company demanded that the bank, with whom they said money had been deposited, should return what the Jamaican Commodity Trading Company claimed should be the outstanding balance of deposits it had made in connection with these milk powder transactions. The Jamaican Commodity Trading Company brought proceedings against the bank, which the bank settled in about January 1992 by paying 32.5 million Jamaican dollars in settlement. Lords, my lady, all this is in the statement of facts and issues, but it's only background, as it were. The bank then sought to recover those amounts from Mr. Seaton and his companies. It froze the 5 foreign currency accounts held at the bank by Mr. Seaton. The date on which that occurred is not certain, but Mr. Justice Sykes, in paragraph 242 of his main judgment, which is at page 289, records a letter from the bank's attorneys dated 21st September 1991.
Sorry, what page is that?
289, my lady. I'm sorry if I'm going too fast.
No, that's fine.
Records a letter from the bank's attorneys dated 21st September 1991, stating that the bank was advised that no further disbursement should be made from any account owned or controlled by Mr. Seaton. Thereafter, on 16th November 1992, the bank helped itself to the equivalent of 15.2 million Jamaican dollars. Lord, that's a rounded figure, from the monies deposited with it by the Seaton parties, of which the equivalent of 9.2 million Jamaican dollars came from 2 of these foreign currency accounts belonging to Mr. Seaton. As I've told the court, as recorded by Mr. Justice Sykes in paragraphs 245 to 247 of his judgment, and as shown by the bank statements at pages 547 and 546, 969,190 United States dollars and 62 cents were taken from one account, account 101,900,561, which was the entire balance on that account, and a small balance of 9,173 United States dollars and 50 cents came from account 109,000,024. The rest appears, though Mr. Justice Sykes said the evidence wasn't hugely clear about this, to have come from the sum in Jamaican dollars, which was represented by a certificate of deposit held by one of Mr. Seaton's companies, Earth Crane. And that appears from paragraph 247 of the judgment at page 290. The bank sued first. Having recouped itself, it nevertheless, on 6th August 1993, issued a writ of summons against Mr. Seaton and Earth Crane, seeking to recover various sums which it said had been paid to Mr. Seaton and Earth Crane by mistake. It also claimed a declaration that it had been entitled to debit what it was described as the defendant's account, defendant singular account. Though actually there were 2 defendants and subsequently a third was added by amendment, with a total of 15.2 million Jamaican dollars. The Judicial Committee will find the bank's amended statement of claim at 360. On 26th August 1993, Mr. Seaton issued his own claim seeking relief against the bank. His amended statement of claim is at page 389 And I am, if the court will allow, going to invite the Judicial Committee to look at that document at this point. For those like me using paper bundles, it's tab 23 in bundle 1. Can I just invite the committee, if they've not done so before, just to run their eyes over the 3 pages of this, and I will make just a few submissions when the committee has looked at it. I draw in particular attention to paragraph 8, where Mr. Seaton has pleaded that the bank knew that Mr. Seaton needed foreign currency in these accounts from time to time for investment and/or use in business enterprises.
Did he give any particulars of that, either in the pleadings or when he was giving evidence?
He gave no particulars in the pleadings. There were a number of requests for further information or requests for further and better particulars which went between the parties, but he was never asked for and never volunteered particulars of that allegation by way of pleading.
Any evidence about it?
My Lord, there was, and I'm going to come to that if I may. We say it's scarcely surprising that the allegation is that the bank knew that Mr. Seaton needed foreign currency for investment and use in business enterprise. It's scarcely surprising because the background to the dispute specifically involved Mr. Seaton in providing foreign currency for the Jamaican Commodity Trading Company transaction. So the whole background to the claim involved Mr. Seaton using his foreign currency for business purposes. Paragraph 9 pleads that the bank knew that actually freezing Mr. Seaton's foreign currency account would frustrate such business transactions or cause Mr. Seaton to lose the benefits thereof. Paragraph 10 claims the sums in the accounts and interest, and paragraph 11 then asserts that Mr. Seaton has suffered loss of business and has suffered damage. As Lord Stephen says, there are no particulars of it. The prayer includes a claim for payment, a claim for account, and a claim for damages. My Lords, it's fair to say that this pleading is not perhaps a model of all that it should be. These averments of loss are not overburdened with particularity. But although I wouldn't recommend my pupils to follow this as a precedent, it does squarely assert that Mr. Seaton has suffered loss by being unable to use the sums in those foreign currency accounts in his business. And that fact is squarely an issue. There was also evidence that Mr. Seaton had in fact suffered loss. Unfortunately, like the pleading, it was also somewhat generic. By the time of the trial, the bank's action and Mr. Seaton's action had been consolidated, and it is scarcely surprising that the majority of the evidence on both sides was mainly directed to matters concerning the milk powder contracts and whether the bank was actually entitled to make the debits, which it did, which were complicated transactions, and there was a lot of evidence about that. These are matters, of course, no longer an issue, and as so often happens where matters reach an appellate level, one is concentrating on one small part of what was a much larger case at the time. Mr. Seaton's first witness statement is at page 473, and the relevant paragraphs are paragraphs 53 to 57 at page 483. And again, can I invite the committee to look at that?
Which paragraphs again, sorry?
The Lords, it's paragraphs 53 to 57. Mr. Seaton put in a second witness statement. I shall do my best. Lord, I'm sorry if I'm not broadcasting effectively. As I was saying, Mr. Seaton put in a second witness statement, and the relevant paragraphs are paragraphs 15 to 17, which start at page 489. And again, can I invite the committee to look at those?
What page? Sorry, 489, did you say?
489.
This is giving us the details of the accounts and the sums that you've mentioned already.
My Lord, indeed. I'm simply giving the committee what evidence there was on this issue. And Mr. Seaton confirmed this in his oral evidence. I could take the Judicial Committee to the transcripts, but perhaps the easiest place to look at it is the quotations in our written case at page 2014, paragraphs 79.2 and 79.3, where we quote them.
Sorry, I can't catch the numbers that you're saying because you're speaking too quietly.
I am sorry, my lady. I will undoubtedly speak fast. It's page 2014.
2014.
2014, my lady. I'm sorry. Well, forgive me. Although it's now more than a month ago, I had a bad dose of COVID, I'm afraid, and I'm still a little hoarse. So I'm not my usual booming self, I'm afraid.
Well, if you're in any discomfort, please let us know.
Lord, I'm much obliged. It's just normally I have no difficulty in making myself heard at the other end of the football pitch, but today I'm plainly having difficulty getting my words across, even this short gap, for which I apologise. But if I could invite the committee just to read those quotations, the last word is across the page in 2015. It's just a convenient place of extracting that. Now, one of the issues which the committee will have to decide, and to which I shall return in the second and third parts of my submissions, is whether that pleading and that evidence was sufficient to justify what we submit was the pragmatic approach of Mr. Justice Sykes at first instance in awarding Mr. Seaton compensation in the form of compound interest for being kept out of his money, my heads 3 and 4, at an average rate over the relevant period. We go back to the chronology.
Where does Mr. Justice Sykes actually do that? Where does he say, I'm not awarding interest for breach of contract, for breach of a contractual term to pay interest? I'm awarding interest on a compound basis at a borrowing rate because he's been kept out of his money.
Lord, at several places,
right.
And may I come to them in the course of the...
Yes.
But I'm certainly going to go there, as it were.
But are we to take it that you have shown us the full extent of the written and oral evidence in support of the damages claim?
Lord, yes.
Thank you.
With except for the evidence concerning the rate, my lord, which I...
Yes, but the claim that there has been a business loss through the absence of this money, the evidence for that we have now seen.
Your lordships have now seen. My lord, I can't be better than the pleadings that were at first instance and the evidence which was led.
Clearly, you have the hand that you've been dealt.
Exactly, my lords. But having said that, it's going to be my submission that it is actually, in the practical circumstances of this case, sufficient to justify what the judge did, and I shall, I hope, make that good in the course of my submission. Just to come back to the chronology, the action was eventually tried before Mr. Justice Sykes over a protracted period. 8 days in September and November 2011, 5 days in March 2012, and 2 days in September 2013. Such are the exigencies of litigation in Jamaica. By the time the matter came on for trial, Mr. Seaton's accounts had already been unfrozen. That took place in about August 1996. And at about that time, he got back a large part of the money which had been frozen, other, of course, than the sums wrongfully debited, which continued to be withheld by the bank.
What do you mean he got back a large part of the money?
Well, he was paid by the bank, my lady.
The freeze was lifted.
The freeze was lifted, so the money was paid. He
could extract
He took it out, you mean?
He'd asked the bank many times to give him his money back, and the bank gave him large parts of it. Again, my lady, the evidence, such as it was not as clear as possible, which was another reason for Mr. Justice Sykes ordering an account in relation to that. But he does say in paragraph 244 of his judgment, at page 289, that much of the money, other than the wrongfully debited amounts, was then paid back.
So there may be a claim for interest at the contractual rate on the money which was paid back in 1996, and there may be interest due at the contractual rate for money which wasn't paid back.
Lord, yes.
Yeah.
Absolutely. All of which ought to come out in the wash in the accounting.
In the accounting, yes.
The main judgment was given on the 17th of March 2014, which disposed of the bank's claim to be entitled to make these debits and held that Mr. Seaton was in principle entitled both to repayment of the sums which had been wrongfully debited and to an accounting. A further hearing about consequential matters took place over 4 days in July 2014. Judgment on that was given on 24th September 2014, and in his order, which is at page 353, Mr. Justice Sykes ordered compound interest at the rate of 27.3% should be applied, both in respect of his order for repayment of the 15.2 million Jamaican dollars, the principal sum, and should be applied to the balances in the account which he had ordered. That is, that effectively it should replace the contractual interest rate, because it would include the contractual interest rate. The bank appealed, and its appeal was heard over 2 days in October 2016. Judgment was given on the 31st of July 2018. As an aside, there was a correction over something which the Court of Appeal of Jamaica had got wrong about an agreement between the parties as to who was to conduct the accounting, but that need not trouble the Judicial Committee because it's not relevant to any issue on the appeal.
I saw the correction judgment, but we needn't be concerned with that. Thank you.
It's only who should do the accounting when it happens. The Court of Appeal's relevant judgment starts at page 92. I'm going to invite the committee's attention to certain paragraphs in that in a moment. Their first finding was that only Earthcrane was entitled to recover the 6 million Jamaican dollars that had wrongfully been taken from the certificate of deposit. And they reduced the judgment in favour of Mr Seaton accordingly. Now, when this matter was first appealed to the Judicial Committee, that was one of the grounds of appeal, but Mr Seaton no longer persists in that appeal, so the Judicial Committee need not be concerned with it. However, the Court of Appeal of Jamaica also set aside the orders for compound interest, both in relation to the principal sum and in the accounting, and substituted orders for simple interest at the rate of 27.3%. And it is those orders which are the subject of this appeal. And perhaps I can just invite the attention of the Council of the committee rather, to page 128, which I mentioned right at the outset of my submissions, and to paragraph 80. And invite the Judicial Committee just to read paragraph 80 of the judgment of the Court of Appeal, which encapsulates, as they say, summary on this issue. What the Judicial Committee will not find in this judgment is the process that I have just taken the committee through, of showing the committee what the pleadings were in relation to the loss and what the evidence was in relation to the loss, or any specific finding, in so many words at least, that those were inadequate for any purpose. Is simply a rejection. Established principles of law do not allow for an award of compound interest. Now, there may be a reason for that, which is that Mr. Justice Sykes, from time to time, appeared to take the view that it was permissible simply to award compound interest whenever people were kept out of their money, as it were under statute, in the way that we would on a debt. So they're concentrating on that.
There's no focus in either judgment on the question of interest as damages.
Well, Lord, it's certainly not in the Court of Appeal. There is, I hope to show your Lordship a little more in Mr Justice Sykes' judgment.
Not much.
Your Lordship is right, not much, but there's some. We say sufficient to justify that. While we're in the judgment, perhaps I can invite your Lordship and my Lady to turn to page 118.
Just before we leave it, isn't the Court of Appeal saying, well, we've had this Privy Council decision in National Housing Trust and Seaton, which they read as indicating that one couldn't get compound interest, that Mr Justice Sykes, in the light of that decision in another case, that is the National Commercial Bank Staff Association case, had also taken the view that compound interest was not available in these sort of cases, and that therefore that leads them to their paragraph 80. So it's back to paragraph 77, is what I'm saying.
Well, your Lordship is right. Yeah. Absolutely, that's what they say. I mean, the earlier Privy Council case was, of course, a case concerned with the powers of arbitrators. And in Jamaica, under the old Act, their powers were considerably more circumscribed than they are now in this country under the Arbitration Act. And they effectively had, by analogy, only the same power as we have under the 35A of the Senior Courts Act, what used to be the 1934 Act, which is still effectively in force in Jamaica, which is well established as a power only to give simple interest. But that's a different power to the power to award compound interest as compensation for being kept out of your money in a commercial case. I'm going to come on to those principles, if I may. Can I invite the committee to go back to page 118 and paragraph 52. Just to note while we're there that no issue has been taken with the application of a rate of 27.3% at simple interest on the sum. I shall come back to my suspicions on rates at a later point, but it's convenient just to look at that. And as I've told the court, subsequent to the appeal, at a date sometime in 2019, the bank paid Mr Seaton the 9.2 million Jamaican dollars with simple interest over that period. The accounting process, however, has been held up by disputes as to the correct approach to interest. Now, my lords, my ladies, that's the end of the preliminaries, as it were. I've shown the Judicial Committee the materials upon which I'm going to base my submissions, as it were. I now come to the details.
Thank you.
As I've presaged in answer to Lord Hodges' questions, properly analysed, we say the bank's actions, which the judge held to be wrongful, have caused Mr Seaton 4 different losses. First, there's the loss of the monies, the 369,000 odd wrongfully taken from the account whose number ends in 561.
Can we call it the 9.2 million? Because if we're going to be swapping between Jamaican and US dollars, it's going to be difficult to keep track of what sums of money we're actually talking about. So when you use that figure, the 350-something thousand, is that the same figure as the 9.2 million?
Those two were converted by the bank as to 9.2 million at the time when it was taken.
But there's no issue before us about that.
My lords, indeed.
Yes.
My lords, indeed. The only relevance, as it were, is if one's talking about an accounting. The accounting will be in foreign currency. It will be in United States dollars. There are two separate orders that were sought and two separate orders which were made. One was for effectively a reconstitution of the accounts. Now that would be a reconstitution of the accounts in their original currencies. The other was for repayment of 9.2 million in Jamaican dollars. Now, it's quite right that there is no issue before the Judicial Committee about the order for repayment of the 9.2 million Jamaican dollars. But it's my submission that the order made by Mr. Justice Sykes was for reconstitution of the accounts as foreign currency accounts, not taking an account in United States dollars and reconstituting it, pretending that it was Jamaican dollars, because it wasn't. And that has an effect both on interest rates and also on loss of use, particularly at a time when there are a gross shortage of foreign exchange in Jamaica. So, Lady Rose is, of course, right that 9.2 is the sum. But one of the problems below is that nobody actually turned their mind to the fact that what had been taken were not Jamaican dollars. What had actually been taken was United States dollars. Mr. Justice Sykes, in ordering reconstitution of the accounts and accounting, is in fact making an order for the reconstitution of the United States dollar account.
So at the end of such an account, the person carrying it out is to treat the $350,000 as having been paid, correctly paid in Bermuda dollars.
My Lord, what will happen at the end of an account like that is that the account will be taken up to the date, the relevant date when the money came back. At that point, it will be converted into Jamaican dollars, and there will then be a set-off against the amount in Jamaican dollars which was paid.
Yeah.
And that may be significant because of changes in exchange rates and things like that. But prima facie, we say, and I'll invite the committee's attention very briefly to the authorities in this, that that's what someone who has a wrongful debit made from their bank account is entitled to have the account reconstituted as if the wrongful debit was, as it is in law, nugatory, not there.
Yes. And it's a claim in debt, is that right?
It's a claim in debt.
You ask for the money, and at that point, they're obliged to pay on your submission.
Absolutely. Yeah. The second loss was the loss of interest on those sums. And as the Lord Hodges said, the evidence established the interest would have been credited to the principal sums on the accounts each month, and so in effect compounded. And as we say, properly characterised, Mr. Seaton's claims in respect of those sums were for contractual debts, for liquidated sums, except in the fact that an accounting is necessary to ascertain what it is, but it's still effectively a liquidated sum. And those claims were recoverable as contractual debts, quite irrespective of anything that was decided in Sempra. Indeed, it would have been recoverable under the law as existed when claims for compound interest and the like were entirely prohibited.
In a sense, it's an aspect of the debt claim. It's a part of the reconstituted account.
Yes.
Yeah.
Absolutely.
You have a contractual claim to the principal sum on that account and the contractual rate of interest.
Lord, indeed.
Yes.
My Lord,
Just looking at the
I doubt that's in dispute.
And looking at the set-off, does the account make an award in US dollars?
well,
And setting off the equivalent of the US dollars that have already been paid. So you convert the Jamaican dollars into US dollars and you make the set-off, or does it work the other way around? Does the account make an award in Jamaican dollars?
My Lord, the account would make an award on this in US dollars because it's a US dollars account. And there would then be a conversion of that amount into Jamaican dollars for a set-off against the Jamaican dollar amount that was paid at the date of payment.
Yes, the account would reveal a sum in US dollars as the total contractual debt. you then convert that into Jamaican dollars and compare it with what was in fact paid.
Lord, yes.
Yes.
Taking into account differences in the exchange rate.
Lord, the exchange rate at the date of payment, because that's the date you've been given,
Yes.
not the United States dollars, but the dates you've been given Jamaican dollars back, which are, by the court order, effectively to be set one against the other.
And the amounts the bank has already paid, that's the principal and simple interest at 27.3%.
Lord, Milady, yes. My third head is the loss of use on those sums from the date they were wrongfully debited on 16th of October 1992 until the date of payment in 2019. And the fourth is the loss of use of the principal and accruing interest on the remaining accounts from the time they were frozen, probably in about September 1991, and I've given the committee the reference for that, until they were unfrozen in about August 1996. And it is only those latter two claims which are claims for damages for breach of contract. Just to complete my submissions about what Mr. Justice Sykes ordered in relation to this. Mr. Justice Sykes held in paragraph 250 of his judgment, reference to which is page 291, that the documentary evidence before the court was incomplete and that it was not clear from the evidence before the court what rates of interest had been applied, whether they were correct rates. It's a matter of fact that the bank's principal witness was a gentleman called Mr. Senior, who had little or no personal knowledge of what had gone on. And indeed, there was an earlier hearing in which substantial parts of Mr. Senior's witness statement had been struck out on the basis that they were not justified by documents which were actually before the court.
Can I just ask this? When a court orders an account in this sort of situation, would it not? Who carries out that account? I suppose?
Prima facie, the registrar of the court in Jamaica.
Right. Okay. Now, the registrar of the court, would you normally dictate to the registrar of the court carrying out the account what the type or rate of interest would be, or would it not be for the registrar to carry out the accounting process and decide for him or herself what the correct approach is to interest?
Two aspects to that. First of all, if the court is directing the account by its office of the registrar, it is always open to the court to direct the registrar as to what should be done in those circumstances, and indeed might in practice be helpful if those matters have already been the subject of debate before the court, so one doesn't retry something that's always been before the court. Secondly, it is the practice in taking accounts for the court to make as clear as possible to the registrar what the registrar ought to be doing. It's simply as a matter of practice, and that's what Mr. Justice Sykes did. In fact, my Lord, what he did was two things here, and actually one of them was unnecessary. He directed the registrar to ascertain for himself, as a matter of fact, what the correct contractual rates were and what interest had in fact been applied, and if there was any dispute between the correct contractual rate and what had been applied, that should be dealt with. And he then said, but if the rate which has in fact been applied is less than 27.3%, you should apply 27.3%. And that's the rolling up of the compensation for being kept out of the money with the contractual debt.
So one wouldn't say to the registrar, it's for you to work out the appropriate rate according to the evidence that you're dealing with on the account.
Well, Lord, in relation to the contractual debt, one would, and that's what Mr. Justice Sykes did. He actually told the registrar to ascertain what the correct contractual rate was, compare it with the rate which had actually been applied, and to work out what the contractual debt was. But he then said, when you've done that exercise, substitute for that rate, whatever it was, 27.3%, by way of compensation. Now,
But if he was just dealing with your category 2,
but he wasn't, my lord. It's our submission that he was dealing with categories 3 and 4 too,
as part of the accounting.
as part of the accounting exercise. And I'll try and explain, if I may, in the 50 minutes left to me, as it were.
I see what you're saying. The first head was category 2, the second head was category 3 and 4. So if there isn't a claim under category 3 and 4, then Mr. Justice Sykes was right to require an accounting of the correct contractual rates and whether they have been applied. If there is a claim for compound interest as damages, you say he's entitled to require the award of the higher sum of 27.3%.
Lord, indeed. Yes. Absolutely, my lord. My lord.
But sorry, just, and the order was that Mr. Seaton should get the higher of the two figures, whichever it was.
Yes.
Absolutely, my lady.
So there isn't double counting because you don't get an award under 2 and an award under 3 and 4. You get an award under 2 and the differential between 2 and the 27.3%.
Well, my lord, it's not a double counting. If the right rate, compensatory rate, is 27.3%,
Yes.
and you get 27.3%, that will include the whatever 6% would be the contractual.
Yes.
So there isn't a double counting, as it were. The first 6 of it you were entitled to contract, and the difference between 6 and 27, forgive me, I'm plucking 6 out of the air. I
Yes.
don't know what the actual rate
No, I think we're agreeing on that position.
4, your D is a different pot of money, so I don't think that...
I'm sorry, my lady.
I thought 4, your D, was loss of the use of the principal and interest of the frozen accounts. So there's no danger of being an overlap between that and B and C. It's only B and C which are alternatives.
My lady, yes. I mean, on the frozen accounts, other than the ones from which the wrongful debits were taken,
Yes.
or in relation to that balance, again, there is a right to contractual interest, which would have been my category 2, if you like. But the registrar is asked, first of all, to work out what that would have been, so as to reconstitute, so as to make sure those accounts have been properly put together, and then to top up to 27.3% by way of compensation on those accounts for the period when they were frozen.
With the figure of 27.3.
With the figure of 27.3, indeed, my lord.
So we're assuming that there is a lower contractual rate of interest, probably considerably lower, payable on these accounts.
Lord, almost certainly.
Yeah.
I mean, the reality, and I would invite the Judicial Committee to take judicial notice of this, is that banks tend to charge more for borrowing than they pay on deposits.
I think you can take that as within judicial knowledge.
I'm grateful, my lord, yes. It's part of making money out of it, as it were.
Yes. And I understand what you're saying. Thank you.
I'm grateful, my lord. The first 2 items of loss I won't spend any time on because, as I apprehend, there is now at least, no controversy. The principles are in the case of Limp Grange and National Bank of Commerce, which are discussed in paragraphs 34 and 35 of our written case. Effectively, the law says that debits that you weren't entitled to make are nugatory. They have no contractual effect. If, of course, you don't pay, you commit a breach of contract, but the debits are just disregarded, and the account is reconstituted disregarding them.
May I ask, is Lip Grange the only authority dealing with this?
Well, there are
first instance cases.
It's a first instance. There are 2 first instance cases, my lord. There is Limp Grange itself, which is at 2126,
Yeah.
and there's a decision of Mr. Justice Webster which applies it, which is the National Bank of Commerce case, which is at page 2149.
And those are the only two authorities dealing with this issue?
Absolutely, my lords. Though it also appears in Paget and various other textbooks of that kind. We submit it's plainly right in principle.
Yeah.
Well, it seems perfectly sound in principle.
Yeah.
Yes, indeed. It seems that the respondents also concede that the reconstitution should be on the compound interest basis, that is, the carry-on of interest to principal each month to which Mr Seaton was contractually entitled. I'm instructed that that's not something which has previously been made clear for the purposes of the account, but it doesn't matter. It's at least now conceded. We submit that it's obviously right, and for the avoidance of doubt, we invite the Judicial Committee to record that concession and its correctness in its judgment. Now, what seems to be in dispute is the rate and whether it should be an enhanced rate by way of damages for loss of use. Can I invite the Judicial Committee to look at the two orders which were made? First, page 355, which is Mr Justice Sykes' order.
Page, sorry?
355.
355, thank you.
Sorry if occasionally I appear to be shouting. I'm trying to make sure my voice projects sufficiently. Page 355. And can I invite the committee just to read that page?
I take it subparagraph 3 of B, it should be determined whether those rates at 2 were correct rates rather than at 1.
Lord, yes.
Yeah.
Might I invite the committee now to look at the order of the Court of Appeal, which is at page 170. And specifically at paragraphs 3 and 4 of the order, which are at page 171.
So that's neither one thing nor the other, basically, the simple interest of 27.3. It's not either the contractual rate, nor is it the loss of... It wasn't intended to be the loss of use rate, was it?
Well, not by the Court of Appeal, my lady.
No.
On the other hand, when I come to my submissions as to rate, I'll show the Judicial Committee that, in fact, in another case, which went to this Privy Council, the rate of 26% was used, just as the rate to be applied on unpaid sums, the statutory, the rate payable under statute, because these were times of high inflation, times of shortage of foreign currency. The Jamaican economy was not at its best at that moment, shall we say, and so rates of this kind, as compensatory rates, are by no means out of court. And I have already shown the Judicial Committee that there appeared to be no exception taken to the rate of 27.3 as a simple interest rate on Jamaican dollars, as recorded by the Court of Appeal. It looks high to us, but our economy works on a different basis. Our currency is thankfully more stable. Now, it's not entirely clear what the effect of paragraphs 3 and 4 of the Order of the Court of Appeal was intended to have. For example, on Mr Justice Sykes' direction to the registrar to determine whether the correct rates were applied on a compound basis on all the accounts. But it appears, we accept to be implicit at least, that that part of Mr Justice Sykes' order which substituted for the correct rate, the rate of 27.3%, was intended to be set aside. And in our submission, the Court of Appeal were wrong to do so.
Do we assume that what the Court of Appeal was there doing was awarding 27.3% under the statute?
My Lord, yes. That would be my assumption. Now, at an earlier stage, my Lord Stevens asked me whether Mr Justice Sykes had actually said anything about compensation. I confess it is not always easy to piece out from the judgment of Mr Justice Sykes his precise reasoning for making the order that he did. However, I do ask the Judicial Committee to look at page 290 in the bundle. Since this appeal is concerned with compound interest primarily, the Judicial Committee will have looked primarily at Mr Justice Sykes' second judgment, the one that deals with consequentials. But this is his first judgment, which deals with principles. If one gets to paragraph 248 on page 290, Mr Justice Sykes has just set out the wrongful debits. And then he says, in dealing with whether interest should be paid, the Court of Appeal of Jamaica has dealt with the matter in British Caribbean against Perrier. And can I invite the committee to read through to paragraph 251 on the next page.
Peyton Lyle is under statute.
It is indeed, my Lord.
Yeah, it's statutory, yeah.
My Lord, these reasonings I fully accept do get quite confused. And there's no doubt that Mr Justice Sykes thought that life had changed, that he had a general power to award compound interest on a statutory basis whenever it was there. But he does in paragraph 251 say Mr Seaton is entitled to interest at a commercial rate on the accounts frozen, even if they had interest paid on them. So,
this paragraph, sorry?
251.
251.
On page 291. Mr Seaton is entitled to interest at a commercial rate on the accounts frozen, even if they had interest paid on them, because he was deprived of their use and would have had to borrow money to supply that which he no longer had access to because of the actions of the bank. So he's effectively, we submit, upholding the case which Mr Seaton had pleaded and supported by his evidence, that Mr Seaton had suffered loss by being kept out of his money, and that the best and most practical way of assessing that loss and compensating Mr Seaton was by an award of enhanced interest on the account, interest at a commercial rate rather than simply the contractual rate to which he was entitled. We say it's implicit in that it's not merely interest at a commercial rate on deposits, but interest at a commercial rate on borrowing, because that's the loss which he's being compensated. He would have had to borrow money to supply that which he no longer had access to because of the actions of the bank.
He may have been awash with money at the time and didn't need it.
My Lord, it is possible. On the other hand, if one's looking at the probabilities, businessmen have a tendency to use their assets because that is what makes money for them, and that is what business is all about.
So you read 251 as taking a step, which is in fact a step from the commercial rate on deposit to the commercial rate on borrowing, as damages for the loss of use of the money as pleaded.
Lady, yes. That we submit is a fair reading of what is being said in paragraph 251.
But there was, in fact, no evidence whatever that Mr Seaton had to borrow any money at all.
My Lord, indeed.
Yeah.
Your Lordship is right. I've shown the Judicial Committee what evidence there was, and I can't do better than that. However, in paragraph 268, is on page 296, what is asked for in 4 lines up from the bottom. The court desires a single rate of interest applicable over the entire period rather than multiple rates of interest over the 23 years since the money was taken. The court is also inviting submissions on the period of interest was paid. And 269, Mr Seaton is asking this court to grant the remedy of an account. He submitted through his counsel that even though he's gotten back some of the monies initially frozen, he's not clear on the rate of interest. The bank alleged that it used to calculate interest. He does not know whether the rate of interest varied over the time. It's not entirely clear whether the bank took Jamaican dollars or United States currency and then converted it to Jamaican dollars. So that's what leads on to the second hearing. Now, my lady, if I can invite the Judicial Committee to turn on to page 315 in the second judgment.
Thank you.
We get to paragraph 22, which I've shown the committee before, but this is its place in the logical structure. In the previous judgment of this matter, the courts asked that an average rate of interest over the period be arrived at so that calculations would be simplified and reduce the risk of error. Mr Seaton has produced material from the Bank of Jamaica for the period 1992 to 2014. The court accepts the average of 27.3 advanced by Mr Seaton.
Could you just give me the page number? I'm very sorry.
I'm sorry.
315.
315.
Yes, thank you.
And that's for borrowing?
My lady, yes. Now,
if we were to be against you on your categories 3 and 4, are you conceding that under category 2 you couldn't get 27.3% compounded?
yes, my lord.
But are you conceding that you've already had everything that you would be entitled to under B?
No, my lady.
No, that's hence the accounting.
Yeah,
It's the account.
that's what I thought.
We simply don't know what, at this stage, what rate of interest would have been granted on the contractual entitlement over those years on the foreign currency account.
Yes.
But standing back and looking at it from a distance, one can say that the inflation of the Jamaican dollar in that period is not directly relevant, because if there was serious inflation of the Jamaican dollar but not of the US dollar, then in Jamaican dollar terms, the foreign currency account was becoming more and more valuable by the day.
Lord, yes. Well,
You're seeking a direction from the board that the account should be actually in US dollars. But if that wasn't, on reading those orders, it wasn't necessarily, it didn't jump out at me, I'll put it that way.
Lord, indeed, but that's one of the things that we would be seeking, absolutely. Yes. And, Lord, just to deal with Lady Rose's point, perhaps I can invite the Judicial Committee just to turn on to page 340, under paragraph 68. Sorry, paragraph 67 and 68. And perhaps I can just invite the committee to read paragraphs 67 and 68. Justice Sykes goes on to be critical of the conduct of the bank in not putting those forward beforehand. We say Mr. Justice Sykes properly made an order for this enhanced rate of compound interest as a practical way of compensating Mr. Seaton for his loss of order. Why do we say the order was properly made? Well, we make 4 submissions. First, that Mr. Seaton had, for practical purposes, sufficiently pleaded and proved his loss. Secondly, that Mr. Justice Sykes was not merely entitled to, but was entirely right to assess Mr. Seaton's loss under heads 3 and 4 by reference to the cost of borrowing. Thirdly, that Mr. Justice Sykes was not merely entitled to, but was entirely right to hold that the cost of borrowing fell to be assessed on the basis that lenders would charge interest compounded monthly.
The loss of opportunity, if there was any loss of opportunity, was to use American dollars. And yet I don't understand why it is that it's the reference to the cost of borrowing in Jamaican dollars.
Lord, I can't improve upon Mr. Justice Sykes' judgment, I'm afraid. Your Lordship has a very good point.
But if there is any loss for cost of borrowing, it shouldn't be, what is the rate that you say should apply? Well, there's no issue, I suppose.
Well, Lord, neither party can go behind the evidence which was put in at the time. There appears from the paragraph I showed you in Mr. Justice Sykes' judgment to have been no controversy about the 27.3% rate. I come back to the point that there was actually a gross shortage of foreign currency in Jamaica. There was no evidence that it would have been easy for Mr. Seaton to go out and actually borrow foreign currency to replace that which he had. Otherwise, why on earth would the whole Prolacto deal, which was the origin of all this dispute, have been necessary? He actually had foreign currency, which was a rarity in Jamaica. So the idea that a significant sum of interest should be awarded on that is not, we say, out with the realms of reasonableness.
Well, except that if the money stayed in foreign currency and was accumulating considerably in value as against the Jamaican dollar, I mean, just leaving it in that account, even if the interest rate was low, may have been a profit-making exercise for a businessman.
Lord, yes, it indeed may have been. On the other hand, if you've got it in foreign currency and you can use it to settle foreign currency debts and things like that at times of extreme scarcity, you can use it to leverage much more than you would have to pay in order to borrow it because you are using it in a profitable business. It's the difference between the risk-free cost of money and the return on risk that businessmen get from putting their money out on the waters, as it were.
But, I mean, if as we take it, Mr Seaton is a very successful businessman, having sums of money of this magnitude in a foreign currency account as a float long term might be a perfectly sensible business venture, for all we know, because the evidence is the evidence.
My Lord, indeed, except, of course, that the evidence is that he was using his foreign currency accounts in relation to Prolacto, that he was asking the bank for his money back. That's common ground, my Lord, that there were a number of demands for the money. He plainly didn't want to leave it there. No. And therefore to infer that was, as it were, his course of choice, or that it was a sensible course of choice, is, we respect, to go against the general grain.
Given he'd been debited wrongly, I'm not surprised he wanted his money back. But
my Lord, he was asking for his money back before the wrongful debit, if your Lordship recollects the
yes.
At a point at which is the dispute with the bank. He didn't want just to leave his money in the bank. He wanted to
use it.
To make use of it. And my Lord,
or deals like the Prolacto deal.
Yeah, absolutely, my lady. And that if my fourth submission is simply that if the first of those three submissions are made out, to roll all four heads of loss, including 3 and 4, into the order for an account, is a sensible and pragmatic way of approaching that issue and achieving substantial justice. I've got 25 minutes left, so I'm going to go, if I may, a little rapidly through each of those 4 submissions. The first of them is the most substantial. My first submission, that Mr Seaton has sufficiently pleaded and proved his loss. As I've already said, he's not been perhaps as specific about the losses as might have been the case. However, simply as a matter of practicality, it's difficult to know precisely what it is that Mr Seaton ought to have pleaded and proved, which would have been useful to the Jamaican court. And in that contention, can I invite the committee's attention to the passage from the judgment of Mr Justice Males in the Equitas case. Now, the case itself is page 2067. And that may be a useful place to look at it. It's quoted in our case at page 2007. But if we just look at it at now, if the committee just has a look at the head note, there's 115 on the left-hand side, and just reads that bit.
So, the head note of Equitas?
Of Equitas. Just so the committee knows what the case is approximately about before I come to the passage. And then just quickly, subparagraph 7 at the top of page 2069. And then can I'm sorry, I'm going too fast. And then can I invite the committee to look at paragraph 123 at the bottom of page 2097. Where Mr. Justice Mayles summarises the principles in that paragraph over 2097, 2098 and 2099. And can I invite the Judicial Committee just to read those, which I adopt as part of my submissions.
Isn't the second principle really a principle of fact, not law?
Well, Lord, yes, it's not a legal rule in our submission. It is, on the other hand, a presumption of fact which courts are not merely likely to do, but should apply unless there is some positive reason not to do so in a commercial case. This is in a commercial context. As Lord Mance said in Sempra, there may be contexts where you don't presume any loss. But in a straightforward commercial case where people are making use of their money for purposes of their business, as in the case of syndicates which have investment income and the like, and in the case of a businessman like Mr. Seaton, who is actively engaged in using his money for commercial purposes, it
seems an extraordinarily broad proposition that in commercial cases, and unless there's some positive reason to do otherwise, the law will proceed on the basis that the measure of the loss is the cost of borrowing to replace the money.
Well, my lords, the principles, first one, damages are in principle recoverable. That's established by Sempra.
Well, that's not in dispute. Sempra vouches that.
Second principle. Secondly, unless there's some positive reason to do other side, the law will proceed on a basis, at any rate in the commercial context, that a claimant kept out of its money has suffered loss as a result. Mr. Justice Mayles says that represents commercial reality and everyday experience. Very experienced commercial judge, now in the Court of Appeal. Specific evidence to that effect is not required, and even if adduced, may well be somewhat hypothetical and of little assistance.
So he seems to be saying that if you're prepared to limit your damages claim to borrowing, then you don't really have to plead it. If you're going to assert that you were going to do something more spectacular with the money, then you do have to give more evidence.
Exactly that. That's what he says. Three, if you're saying something more than the cost of borrowing. But in other cases, I do not consider it's necessary for the claimants to produce specific evidence of what it would have done with the money or what steps, if any, it took to borrow or otherwise to replace the money of which it was deprived. Often impossible, or at any rate extremely difficult to produce such evidence, because it means attempting to disentangle a claimant's overall business operations in an artificial manner to attribute specific activities such as borrowing to the non-remittance of specific funds. Don't forget, one's not talking about the freezing of the entirety of the assets of a business, either in the Equitas case or in Mr. Seaton's case. He was a businessman who had lots of accounts and lots of businesses. This bit of his business was frozen. And in those circumstances, to require someone to prove, hypothetical, what I would have done but for this, and to provide evidence of that. It is inviting, as Mr Justice Mayall says, someone to try and construct a not very realistic hypothetical, and a complicated one at that, and that in commercial cases it is simply sufficient to say, well, commercial people who use their money in their business, who are kept out of it, have suffered a loss, and the conventional measure of damages for being kept out of that money is the cost of borrowing. If you want to prove a specific loss beyond that, you've got to prove it. But beyond that, it's the cost of borrowing.
That's a very, very broad principle. This decision, first instance decision, was decided 9 years ago. Have there been examples of this principle being applied thereafter?
My Lord, yes. And we mention them in our case. I've only referred your lordships to that, but if we go to our case, sorry, if I just extract...
Just as a matter of commercial reality, lots of businesses keep money in cash.
Well, some. But keeping money in cash for the risk-free cost of
Instead of borrowing, they have a float.
Well, my Lord, lots of businesses have a float. That's undoubtedly right. Any prudent business keeps in cash or within the borrowing limit the amount it's going to require. It'll have a cash flow projection for these things. But part of that cash flow projection, the amount that it needs to keep, as it were, will be what resources are available. If suddenly a chunk is taken out of that, it has to replace the cash flow projection so that it never dips below the amount it requires to pay its debts as they fall due.
It may or may not.
Well, may or may not, but if they do, then they may be in trouble, because that's the point at which they become insolvent under the definition in the Insolvency Act.
But
and the directors may end up being liable for wrongful trading or the like.
But if you're taking this borrowing figure, will that usually or always be a compound interest figure or not necessarily?
Well, again, Mr Justice Mayall says that it answers itself. Because if you're talking about borrowing on a commercial basis, the reality is bankers always charge compound interest. We've recognised that in many cases in this jurisdiction. The Pineos Shipping, for example, National Bank of Greece against Pineos Shipping, 1990 appeal cases 637, Kitchen and Hong Kong and Shanghai Bank, 2001 All England Commercials 787 789. It is the practice of bankers that they charge compound interest. It's well recognised in this jurisdiction, and it's plainly well recognised in Jamaica, as Mr Justice Sykes said, referring back to the Negril Holdings case, which, if the court the committee remembers, came to the Privy Council, and the Privy Council actually set aside the orders made by the Jamaican Court of Appeal on the basis of evidence. They examined the evidence, and the universal evidence of the bankers in Jamaica was that their compound interest was charged on a monthly basis. Again, not something that it's really difficult to assume is correct, because, of course, they were paying compound interest on a monthly basis on deposits, and they're scarcely likely to deal with interest on a less favourable basis when people are borrowing from them. Not merely as to rate, but also as to compounding. It was certainly a finding that was well open to Mr Justice Sykes in this case, to say that borrowing would necessarily involve compound interest.
So the effect of sempre metals on your view is that commercial parties who've lost the use of their money will just about always be able to recover compound interest as the cost of borrowing?
Well, Lord, unless there is a reason not to do so.
Well, that is not what sempre metals says.
I'm sorry, my Lord?
That may be what Mr Justice Mayall says. It's not what sempre metals says.
Well, my Lord,
they say in terms that you can't, this claim is permissible, but you have to plead the loss as damages, and you have to prove it. And you're saying, in a commercial context, we must assume that every businessman who is kept out of money would have suffered loss, which is assuming in a commercial context that every businessman is successful financially, and if he or she had the money, they would use it for a profit-making purpose rather than invested in what might be a loss-making business. Just to generalize to the extent that if it's a commercial context, you assume a loss in the form of borrowing at compound interest seems to be a fairly sweeping assertion.
Well, Lord, can I do two things? First of all, answer your Lordship's question as to whether there was any other case.
Yes.
In paragraph 68 of our written case, we cite the case of Raymond Peacock against Imagine Property Developments. Again, a first instance decision of Mr Justice Stuart Smith. And it's,
yes.
The relevant passage is
It's quoted.
2249 to 2250. Since I've only got 10 minutes left, I won't invite the
No. It's sufficient just to give me the reference. Thank you.
To give the reference. And it's quoted, as I say, in paragraph 68 of our case in 2009. And we also rely upon another first instance case which predates all of that, the case of Earl's Terrace against Nilsson Design. And the relevant passage is at 2062. And again, it's referred to in paragraph 69 of our written case. And, my lords, what we say about Sempra is that the rules in relation to loss of use are assimilated effectively in Sempra, the majority not agreeing with Lord Mance that there's some peculiarity about it, to the rules in relation to any other claim for damages and loss. We get rid of all the old law, as it were, and you can claim for your loss, but it's a claim for damages, so it has to be pleaded and proved to the extent required by law. But if the reality is that in commercial cases, and Mr Justice Mayles here says, and Mr Justice Stuart Smith subsequently agrees with him, that in a commercial case, businessmen who lose the use of their money prima facie suffer some loss from it, having it's one of the problems of measuring the time value of an asset, if you like. Particularly, I mean, a problem as the Judicial Committee will have come across in the relation to assets like warships and things which are not used for profit and things like that. There is always a difficulty with that. But there comes a point at which the court says, we can take a conventional measure for this. In a commercial case, businessmen normally use their money to make profits. How do we measure their loss of use, the deprivation of this asset? Do we require them to construct the counterfactual, I would have done this, and then to measure that against the knowledge of the other party and to see whether it comes within limb 1 or 2 of Hadley and Baxendale, and in any event to go back and try and disentangle from their business what they'd have done in relation to this specific sum of money in a particular account? Or do we step back, as you do in sale of goods cases and things like that, say, well, actually, if it's nothing out of the ordinary, unless there's a reason to do otherwise, the cost of borrowing that money is a good proxy, it is a good stand-in, as it were, for the loss of use of this asset, which is money. And that, in fact, it doesn't help the court very much to have very much pleading or whatever else, because, truthfully, that's a much easier and more sensible measure, which is inevitably going to come within limb 1 of Hadley and Baxendale rather than limb 2. It's not going to require great evidence of what was in the parties' reasonable contemplation at the time they made the contract and all the things like that. It's the probable result of it. And that's, we say, the pragmatic approach taken by commercial judges. And it's not inconsistent, we say, with Sempra. On the contrary, it is an application of the freeing of the English law from shackles, which Sempra represented in relation to damages for interest, not, I'm afraid, in relation to damages for restitution, for reasons discussed in the Prudential case. But the pragmatic approach is as described, we submit, and rightly described by Mr. Justice Mayles in that decision.
I should just draw to your attention that I think there is another first instance decision of Mr Justice Tier looking at these sort of issues, predating slightly the Mr Justice Mayo's decision, the Abelazov case, JSC Bank, 2013.
Yes. The Abelazov case.
Yes, where Mr Justice Tier seems to take a rather different view.
Lord, yes. But the context of that case was very different from the kind of cases that we were looking at here. The Abelazov litigation was, how can I put this, not uncomplicated, and had its own peculiarities in the facts. What I note in passing, that although I'm actually familiar with the case, it's not a case that's cited against us.
No, I think we are conscious of it, so if you want to make any submissions on it, I think you'd better have.
Absolutely, my Lord, I can't usefully say more at this stage than I have already said. Perhaps when I come back to reply, I may have something additional to say.
Yes, it's reported in 2013 EWHC 867 to let the respondents know of its existence.
Lord, I'm grateful. Well, Lord, just cantering quickly through. If Mr. Justice Mayles is right, and it's not necessary to produce specific evidence of these matters, why is it necessary to plead them specifically? As I've said to the committee, I would not hold up the pleadings on either side in this case as examples to teach pupils. But the purpose of pleadings is to define the issues and to ensure that the other side knows the case they have to meet. Mr. Seaton here has specifically pleaded that he suffered loss through being kept out of his money. The bank therefore knew that it had to meet that case. As to measure, Mr. Seaton has not asserted that his loss exceeds the cost to him of borrowing, which is, we submit, the conventional measure of damages. Just as the difference between the contract price and the market price is the conventional measure of damages in many sale of goods case. It might be said against us that he should have pleaded in terms that his loss should be measured by compound interest at the cost of borrowing and said what that cost was. But no objection was taken by the bank at the hearing at which rates were being discussed to the figures then being put forward as typical rates. And if I can, just for the note of the committee, refer to the Financial Institution Services Against Negril Holdings case. Paragraph 37 at page 2373 says 26% was the reasonable commercial rate fixed in that case under the statute. So, as I say, I've submitted that Mr. Seaton had, for practical purposes, sufficient pleaded and proved his loss. It's a deliberate formulation. I don't say, as I say, that the pleadings are perfect, but the rules of pleading are the servants of justice, not their masters. And when a pleading point is taken, the effect of which is determinative of a case or a specific claim, the issue is not whether the pleading is exactly as it should have been, but whether it served its purpose in the circumstances of the particular case, of defining the issues, enabling the court and the other side to know the case being put forward and the other side has to be meet. We say that's clearly been achieved here. There could have been no doubt in the bank's mind that Mr. Seaton was alleging loss through having been kept out of his money, and no doubt about the claim for compound interest at the 27.3% as such compensation, given that there was a specific hearing about it, of which interest rates were to be discussed and the issue of compound interest was to be discussed. And the proof of what I've just said, and there is proof of it, is the absence of any arguments from the bank, whether before Mr. Justice Sykes, Court of Appeal or Jamaica, or this committee, based upon injustice or want of notice. The respondents have at no time alleged that they have been prejudiced in their conduct of the case, and that it is therefore unfair to allow Mr. Seaton to pursue his claim on this basis. Their argument is simply that the technicalities of the law do not permit it, and that was what the Court of Appeal of Jamaica held. That was the argument before Mr. Justice Sykes, as appears from paragraph 22 of his second judgment at page 315. And we say it was the basis of the decision of the Court of Appeal, which appears to reverse Mr. Justice Sykes, not because they said his decision was unjust or unfair, but because they said the rules did not permit it. As to the point that these were foreign currency accounts, whereas the rate was a Jamaican dollar rate, we make three submissions. And I accept entirely that since the accounting is to be in dollars, it would have been better to have picked a specifically dollar rate. First, the time to make that point and put in evidence as to the proper rate was at the consequential hearing before Mr. Justice Sykes, not before the Court of Appeal, much less before this judicial committee. The rates in fact put in by the bank were deposit rates, not borrowing rates, and we say the relevant rates were the borrowing rates. I've shown your Lordships, my lady, the paragraph 68 of the judgment. Secondly, one has to bear in mind the acute shortage of foreign exchange at the material time in Jamaica. It by no means follows it would have been open to Mr. Seaton to borrow foreign currency at lesser rates. This is a point which, if it was to be explored at all, should have been explored in evidence for Mr. Justice Sykes, at the very latest on the second consequential hearing. Thirdly, the bank expressed its claim for a declaration, and the courts of Jamaica expressed their orders for repayments in terms of Jamaican dollars, not United States dollars. That's not an answer to the claim for an account on the basis of reconstituting the foreign currency account, but it is an explanation why the parties concentrated on the Jamaican dollar rates and may be of significance in relation to the order for repayment of 9.2 million Jamaican dollars and interest. If I can trespass for another 5 minutes on the Judicial Committee's time, yes. I'd be grateful. I've not got very much to say on my next three submissions, but I would like to say something. Our second submission, that Mr. Justice Sykes was not merely entitled to, but was right to assess Mr. Seaton's loss under heads 3 and 4 by reference to the cost of borrowing, is based upon the approach of Mr. Justice Males in the extract I've cited. We submit that that is an entirely convenient and conventional measure of loss, and that although it is a broad statement, as my Lord Hodge has said, it is one which is founded in commercial reality. If the judges of the commercial court, who have great familiarity with these things, like Mr. Justice Males, take the view that that is founded in commercial reality, we respectfully submit that it is something that the Judicial Committee ought to think carefully before rejecting as being not founded on the practice of mankind. After all, one of the purposes of having a commercial court in this country is to ensure that it is people who are familiar with what happens to merchants and the like. Our third submission was that the cost of borrowing falls to be assessed on the basis that lenders would charge interest on monthly compounding. That's a natural consequence of the cumulative effect of being kept out of one's money. The Supreme Court said so in Sempra, and Mr. Justice Males held so in Equitas. Mr. Justice Sykes took into account the evidence in the Negril Holdings case in paragraphs 17 to 21 of his judgment, starting at page 313. The respondents are undoubtedly right to say that that was not strictly evidence in the present case. However, as I've said to the court, the practice of banks of charging interest on a compound basis is notorious. The practice in Jamaica was subject to thorough review in the Negril case, and again was found to be both certain and notorious. There is nothing in the evidence to suggest that that was not the practice of the banks, and indeed the bank could have said that would not be the practice, but did not. And we also say it's improbable in the extreme that banks would charge for borrowing on a basis less favourable than that used for paying depositors. In the circumstances, it was open to Mr. Justice Sykes, and judged with experience of the realities of Jamaican commercial life, to take judicial notice of the commercial realities without the need for specific evidence. And our fourth submission is that it was a sensible and pragmatic way of dealing with it. By rolling it all into the account, you have the advantage of giving compensation only in relation to the particular amounts that are frozen for the particular time that they're frozen in the particular accounts that are concerned. It is effectively an inquiry as to damages under the guise of an account. And we submit that that was a perfectly sensible way of doing it and does not result in any double compensation because the higher rate of interest subsumes the lower contractual rate. It gives proper reward for the time value of money. And on that basis, we invite the Privy Council to set aside the order of the Court of Appeal of Jamaica and restore the order of Mr Justice Sykes in relation to the account, making clear that the account should be taken on a compound basis and in relation to the currency of the particular accounts concerned. If that is done, nothing more than that is required. Mr Seaton will, of course, have to give credit for what he's received. But finally, I should deal with the order for repayment. That is expressed to be in Jamaican dollars, even though the deprivation was not. That issue is not explored in the judgments. The order for repayment does not compensate for the freezing and does not on its own give Mr Seaton the account of what he should have had under Head 2 or the inquiry as to whether the entries posted by the banks to the statement of the other accounts gave him all that he was pleaded to. And if we're right that Mr Seaton has sufficiently pleaded and proved his loss, he should have been entitled to be compensated by compound interest on the sum withheld at the borrowing rates for entities comparable to him. And since that sum is measured in Jamaican dollars, there can be no objection to the Jamaican use of the Jamaican dollar rate on a compound basis in relation to that. Would your Lordships, my lady, give me a moment to make sure I've covered all the things that I'm asked to do? Lords, my lady, unless I can assist you further, that concludes my submissions.
Yes.
Sorry, Ben, do you want to? No. At the moment, you have the benefit of an order giving you interest at 27.3% on a simple interest calculation. That may end up more or maybe less than the contractual deposit compound rate of interest over the period. But are you saying that we must set aside that order of the Court of Appeal in any event? Because it's wrong in any event?
No, my lady.
Or what are you saying?
As to that, I'm saying two things. The first is, if the Judicial Committee is with me in relation to the account, then there will be the order of the Court of Appeal of Jamaica has been performed, and there will be a set-off of the amounts payable in relation to that, and so nothing more is needed, as it were. That has been done, so the Judicial Committee need do nothing about that order, because there will simply be a set-off, and we get our compound interest in the account. But if the Judicial Committee is against me in relation to the account, we say that the order setting aside the compound interest aspect in relation to the 9.2 million Jamaica dollars ought to be set aside, and the order of Mr Justice Sykes, which gave compound interest, not simple interest on that sum, ought to be restored on the basis that that is the compensation for being kept out of that 9.2 million for the period. In other words, it should be at a compound rate in order to compensate us not merely for the loss of the contractual interest that we received, because the 9.2 million takes no account of contractual interest, but also to compensate us for the loss of the use of the money over that very protracted period. I'm reminded by those behind me that simple interest is unlikely to be more than interest at a correct rate. Jamaican rates were very high over that period.
But was it a time of particular inflation in Jamaica?
Well, it was sadly, as I understand it, there was a time of comparatively high inflation for a very long period in
Yes.
Jamaica.
Yes.
And I've drawn the committee's attention to the Negreville Holdings 26% as being
Yes.
the statutory rate, as it were. That's the basic compensation being kept out of your money. And in those circumstances, the sum concerned is not excessive. However much it may feel to us in times when our bank rates are in the very low single digits. To be a very large sum.
Thank you very much. Mr. Hilton.
May it please you, my lords, my lady. If I may start where my learned friend got it towards the end, that is the question of pleading and proving the claim for interest as damages and for compound interest. And I would start, my lords, to answer my lord Hodges' question as to whether there are other first instance cases that consider this issue. In addition to the Bliazov case, there is in fact a much more recent decision, F&T Terrix, Terrix Limited, and CBT Global Limited, which was decided in December 2021, citation 2021 EWHC 3379.
Did you make a copy of this
I did, my lord.
judgment available to Mr. Salter before the hearing?
Not before the hearing, my lord.
Not before the hearing.
No, my lord.
Just literally now.
My lord, frankly, I was reluctant to rely on a first instance case.
Yes.
But
Well, he will have to have a full opportunity to reply to it.
certainly, my lord.
Please.
And I apologize to my learned friend for just.
Thank you.
Thank you.
My lords and my lady, one paragraph is particularly useful, paragraph 80, because in that paragraph, the learned judge referred to the cases my friend has cited, Peacock and Equitas. You will see that in paragraph 80, the learned judge said that in his judgment, the claim for interest as damages was far too speculative a claim to succeed. He referred to the cases cited, and if I just pause to allow your lordships and my lady to read the rest of paragraph 80.
So, I mean, is this postulating a sort of interim ground that one simply would have done nothing? One wouldn't have borrowed. One would restrain oneself from expanding one's business, but there's no need, or it's not appropriate, at least in some circumstances, to assume that the person deprived is going to go out and borrow at potentially quite high rates on a compound interest basis.
Yes, my lord. And in addition to that, there's a difficulty in then assuming the terms on which the person would borrow. So, for example, one cannot assume, we would submit, that one would borrow on compound interest with monthly rates. And I will come to the Negril case my lord, and another decision of this board on this issue. So that I merely cite this as an indication.
I mean, a businessman like Mr Seaton wouldn't just necessarily borrow effectively on overdraft from a retail bank.
Exactly. Yeah. And your leadership has raised a point that I was going to raise about the Negril case. Because the financial institutions, services, and Negril dealt specifically with overdrafts. And I can take you to that in a minute. What they held was, the evidence in that case was that the banks who gave evidence said they all charged compound interest on overdrafts. And Justice Learned Trial Judge in our case took that to be a decision that borrowing in Jamaica is on compound interest terms, which was neither the evidence nor the holding in that case. May I just take you to that case now, my lords? At page 2372, I'm sorry, 2372.
Can I just before you leave this case, sorry, I was just reading through the paragraph. I mean, the judge concludes at paragraph 80, last line, in short, in my judgment, this is a case where the normal measure of a commercial interest rate on damages awarded is proper compensation.
Yes. But I think the issue was there's no compounding.
Or was it?
Yes, the claim we see at paragraph 73, there was the return of the deposit, the loss of profit on the resale, further loss of profit, and damages for the loss of opportunity to use the sums for further profitable transactions assessed at a commercial borrowing rate, 7% compounded monthly. Seems to be the claim.
I understand usual measure to be as would be allowed pursuant to the statutory discretion.
Thank you.
So that actually the judge rejected that 73D measure.
Yes, ma'am. May I take your lordships to the Negril case? That case begins at 2359. Decision of this board. And at starting at 2370, the board summarized the evidence given by various bankers. And after that summary, at paragraph 34, at page 2370, Lord Walker, who delivered the judgment, said that the evidence established that interest on overdrafts with commercial banks, etc. So that it, as my lady.
It doesn't necessarily mean it's an unauthorised overdraft. It would be an agreed overdraft, but it's still an overdraft rate.
It's certainly. Yes. There was an issue in the case as to whether they were unauthorized or not, but certainly there were overdrafts. And I said this merely to say that this certainly cannot be authority for the suggestion that this board has held that in Jamaica, borrowing is routinely done at compound interest base, which is what I think Justice Sykes took from it. My lords, some years after Chambers, was decided by the House. The Privy Council decided the National Housing Trust and Seaton case, which begins at 2155 of the bundle. And while that case dealt primarily with powers of arbitrators, the board also discussed the decision in Sempra and the requirements for pleading in these circumstances. And for that discussion, if I could ask your Lordship, Mr. Lady, to go to page 2164, paragraph 31. And you'll see that at that paragraph, Lord Mance is continuing with the history of the matter. And going up to the Sempra Metals decision. And the last sentence on that page beginning, it was thus open. Confirmed and reiterated the position taken in Sempra, I think by all the members of that court, of the need for pleading and proof. Such claims are for actual and real damages, not theoretical. And of the very broad statement of principle by Mr. Justice Mills in Equitas, I submit, is not consistent with this authority or with the House's judgment in Sempras.
You say it's wrong, do you?
It is wrong, Miller. In the present case, my learned friend took you to what I think he fairly described as general statements in both the pleadings and the evidence. Those pleadings we submit are deficient not only because they do not use the word compound, but they do not indicate that there was borrowing, that there was any specific amount that was being claimed as a loss as a result. That there was any specific business opportunity lost or a consequential amount claimed as a result. And if the court is being invited to assume a compound interest claim, there's no evidence as to the form, the type, terms of compounding that were either usual or, more importantly, incurred. And so we submit that the pleading and the evidence in this case were therefore deficient.
Well, I mean, the pleading is one thing, the evidence may be another. I mean, the evidence in this case is clearly exiguous. We don't know whether Mr. Seaton had to borrow any money at all. And perhaps more importantly, we don't know whether, in the context of high inflation, keeping money in a US dollar account and earning interest on that account in US dollars might have been a very good investment of itself.
Yes,
So, given that he was getting a return on his money, it's not a straightforward case where the money is completely deprived. The claimant is completely deprived of his money. This is a case where the money was in an interest-earning account in foreign currency at a time of high inflation, and we simply don't know whether there is any difference between, in terms of profitability, between doing that, keeping it there in a foreign currency, being able to convert it later into Jamaican dollars at a higher value of Jamaican dollars, and investing it, taking it out, converting it into Jamaican dollars and investing it in the market at the time. We simply haven't a clue.
that is so, Madam. If I may make one final observation on this point, one final submission, my Lord. My learned friend has submitted that the court ought to consider the circumstances that are usual in commercial markets and in commercial borrowing. And of course, one needs to be mindful that different markets and different jurisdictions may have very different circumstances. And so assumptions that may be appropriate in a mature market may not be the same in others. It increases, and I think, my Lord, reinforces the point, the need for evidence and pleading as to what happened in a particular case.
So is that an alternative submission then, that we wouldn't actually need to overrule Justice Mayles? Because one could simply distinguish this as being a different jurisdiction.
It's an alternative submission, my Lord, because I actually think, respectfully, that Justice Mills is wrong in any market.
Yes, I understand that.
But I add the point that even if he's right in the circumstances that he was considering, he's not necessarily right in another. My Lord, on this point, both the Court of Appeal and Justice Sykes actually agreed, because they both were of the view that Mr. Seaton had not pleaded and proved compound interest loss. The difference was that Mr. Sykes did not think he needed to, while the Court of Appeal thought he did. It is our submission that they were both right in relation to the lack of evidence and pleading. But that the Court of Appeal was right, that consistent with the authorities and principle, this sort of claim, this sort of loss, like all special damages claims, ought to be specifically pleaded and proven.
There must be limits on what has to be proved. I mean, there is some substance in Mr. Justice Mayles' assertion that a businessman with complex business interests will not be able to prove how a particular sum of money would be used in his business. There is no doubt, I would have thought, about that. But you're saying in this case nothing at all was proved other than the assertion that he would have used as in his business.
Yes, that is so, my lord.
Yeah.
I was just, your lordships will have noted from our written case at 2034, paragraphs 52 to 55, that we noted that in all the cases referred to by my learned friend, there was some evidence that went well beyond what Mr. Seaton did. And our comment about the evidence in Sempro is perhaps particularly relevant to my Lord Hodges' point, which is there was evidence of it being in a net borrowing position. In other words, not specific evidence of a specific loan, but that net borrowing position at least indicated some level of evidence, which, and I agree, the detail of the evidence may vary, but there must at least be some. And as we've indicated there.
Yes, you mentioned Earl's Terrace. I mean, that is an interesting case, because at page 2010 in the Appellants case, there's a quotation from it. And what the learned judge there is suggesting that it would be possible to quantify a loss by reference to a reasonable rate of return that could be achieved from the funds. For example, the rate of interest which could be obtained by depositing the funds to earn a commercial rate of interest.
Yeah.
Which again leads to the question, well, these funds were deposited and earning a commercial rate of interest.
Indeed.
Yes. Would that be a convenient place
it would be convenient
to adjourn? The board will now adjourn.